Today we're going to be taking a look at the lawsuit filed by Timothy MckImmy versus OpenSea, the NFT platform, the leading NFT platform out there. This lawsuit was filed in the United States District Court for the Southern District of Texas, Houston Division. We're going to be taking a look at a couple issues today. Obviously, we're going to take a look at the lawsuit. We're also going to take a look at the terms of service of OpenSea to see what the terms of service say about where a lawsuit can be filed, if a lawsuit can be filed, the arbitration provisions, the no class action provisions found in those proceedings, and of course the limitations of damages that virtually all of these platforms include into their terms of service. And there's going to be a couple takeaways here, but one is that one of the biggest risks in NFTs is the marketplace itself, because in a marketplace like OpenSea, is generating hundreds of millions, billions of dollars ultimately worth of sales. But the terms of service are going to essentially say that you're using the platform as is, and even if they steal your NFT, they're not liable. So would you use a business platform where the platform precluded you from really litigating against them and absolve themselves of any action or omission, whether reckless, intentional, or otherwise? Now, whether or not the law actually is going to enforce those types of contract terms is another issue and is the risk. But with so many of these platforms, instead of embracing their responsibility, instead of embracing their obligations to their users, instead of taking a reasonable approach to what most people are going to expect they're going to stand behind, right? Their lawyers simply come in and absolve themselves of everything. So let's take a look. Let's dive in. Let's take a look at this lawsuit filed by Timothy MckImmy versus OpenSea. This lawsuit deals with Timothy McKimmy's loss of his OpenSea Bored Ape. And so this is the page here for the Bored Ape at issue. Note that OpenSea has marked this page as reported for suspicious activity. Buying and selling this item has been disabled. So as of right now, Jack W., who isn't the person who took the NFT illegally, who hacked the system, who exploited the system, this is someone who actually bought for several $100,000 the NFT from the perpetrator. So here's the page. You can see essentially the history here. We've got TJ MckImmy, that's the plaintiff in the lawsuit. He received the NFT. He owned the NFT as a result of the exploit of OpenSea's platform, a flaw in the system, a flaw in the code. This person here, OEA12C, was able to take control of this Bored Ape worth hundreds of thousands of dollars, if not millions, for 0.01 ETH. And so Timothy MckImmy did not authorize the sale. He did not have his NFT, his Bored Ape, for sale. The NFT was essentially stolen from him as a result of a flaw in OpenSea's system. And you can see here we've got the transfer of the NFT to OEA12C and then a sale to Jack W below market value at 98.9 ETH. Jack W now owns the NFT. It's unclear whether or not he's got any relationship with the perpetrator or not, but you can see he looks to be a legitimate NFT aficionado. He's got a lot of NFTs here. You can see this is the subject NFT 3475, which is currently frozen, but he's got a number of any other NFTs. He probably saw it at the reduced rate, at the below market rate, pounced on it, not knowing it was stolen. All right, so clearly by all reporting, it certainly appears that OpenSea is fully responsible for what happened to this NFT. So let's take a look at the lawsuit that has been filed in Texas. And basically the defendant is listed as OpenSea, a foreign corporation headquartered in New York. It's unclear why they sued OpenSea. OpenSea is really a DBA, as you'll see from the terms of service. OpenSea is owned by Ozone Networks Inc., DBA OpenSea. Sometimes these lawsuits get rushed to court. I'm not sure if this one was, but pretty unclear why they wouldn't have named the actual entity as a defendant. I'm sure that will get fixed down the line. In any event, factual background, they're basically saying OpenSea was aware of its security vulnerabilities in its platform. In having full knowledge of this, they failed to protect and inform users, should have shut down the platform. Instead, they left the platform open. Plaintiff's Bored Ape 3475 was stolen as a result of these vulnerabilities. And you're going to see here that the plaintiff in this action, Mr. MckImmy, says he tried to resolve the issue, was unable to do so with OpenSea. You're going to see some other interesting allegations. Forums have indicated that because this isn't the only person that this happened to, other Bored Ape NFTs were also stolen on the OpenSea platform. And the allegation is that forums have discussed instances where defendants have approached the victims of these thefts with non-disclosure agreements, offering floor price in order to try and settle with them outside of court. This particular plaintiff apparently was not approached. So we've got causes of action: negligence, a bunch of failures with regards to the vulnerability. Second cause of action: breach of fiduciary duty, trust contract, and implied contract. OpenSea failed to protect the integrity of its systems and failed to timely notify or warn plaintiff and others of the severity of the vulnerabilities in its code. So that's the lawsuit filed in Texas. First thing you want to do when taking a look at these issues is take a look at the terms of service that Mr. MckImmy would have had to agree to on OpenSea. These were last updated December 31st, so this would have been the terms of service that likely are going to apply to this action. You're going to find a lot of things in these terms of service, but basically what they're going to say is, don't use our platform if you have any interest in NFTs, or if you do buy an NFT on our platform, get it off the platform onto a hard wallet as quickly as you can, because OpenSea is not going to stand behind its service. And it's an unfortunate thing that we see in a lot of these terms of service. We will see in the future, especially with Web3, we're going to see that either DAOs behind the Web3 application or the projects in the first instance are going to stand behind their product. They're going to stand behind the representations that they make to the public. OpenSea is not one of the tech companies that is going to stand behind its own failures, negligence, recklessness, etc. And you're going to see that their attorneys are either going to fight this out in court or try and sell it privately in order to preserve their reputation. In any event, you're going to see one of the items in 11 that their lawyers have drafted in is a disclaimer of any responsibility for vulnerabilities to the system or any features of the NFTs. This won't deal with features of the NFT. This is a vulnerability of the system. So this a good argument for the lawyer, for the claimant in this case, is going to be that this is not a vulnerability due to a feature of the NFTs, and so this particular provision won't apply. Paragraph 12, assumption of risk. Basically, they're making you assume a lot of risks with regards to, speculation in the NFT market, these types of things. Interestingly, they're not asking you in any of these provisions to assume the risk of recklessness, negligence, or intentional behavior by OpenSea. But here we do get to paragraph 13, limitation of liabilities, and here's where they're saying, look, in no event is OpenSea going to be liable for loss of use, indirect damages. It's unclear whether or not this would preclude an action for direct damages, but they are trying to limit their liability for negligence and breach of contract. Good lawyers going to be arguing this provision as either overly broad, inconsistent with the marketing language on the website, and otherwise not applicable to the situation at hand. But there is language in here that the lawyers have inserted that certainly OpenSea will exploit, which says that they are not responsible for any liability resulting from the delivery, use, or performance of the service, and you use the service at your own risk. here is another provision that is interesting, and that is that OpenSea is saying that you can sue them only for $100 or the amount received by OpenSea for its service directly relating to the item. So that would be their percent, their service fee. So they're essentially limiting their liability to $100 or a couple $1,000s here. Get down to dispute resolution. Contrary to the lawsuit that's been filed, OpenSea is making everyone agree to arbitration. Any dispute with regards to OpenSea will be resolved with binding arbitration. You have to engage in settlement discussions with them first, wait 30 days, and then you can only file arbitration with JAMS in order to resolve your dispute. So we certainly will see any number of defenses filed in this lawsuit by OpenSea, by the parent entity of OpenSea, which will be Ozone Networks Inc. And one of those defenses is certainly going to be arbitration provision. They're going to file a motion to dismiss, forcing this into arbitration. And arbitrations, although they're not necessarily confidential, they're not public documents filed in court. So again, OpenSea has angled itself here to be able to keep its own negligence, recklessness private from the public. All right, so let's take a look here again. Here's the subject ape. Jack W. You're going to see is got his own page. One of the beautiful things about blockchain is the transparency with regards to blockchain. If we were to click on the perpetrator here, OEA12C, it's going to open up a 404 page. So clearly they've got OEAC12 locked down on this wallet address. And so that is certainly something, but of course you can just open up another wallet and continue to perpetrate crimes. So this is going to be some Etherscan information for this particular person who's involved in the sale of the particular Bored Ape. You're going to see there's more public information concerning the ERC 721 token that's at issue here. That's the transparency we're talking about. So will this and other Bored Ape proceedings be successful? It's going to really come down to whether or not OpenSea wants to fight to the death, stand behind its contract language, or whether or not OpenSea wants to stand behind its reputation and try and preserve its reputation by doing the right thing. If you are an NFT aficionado collector, you need to be aware that OpenSea's contract language, terms of service, contain these limitations, contain an arbitration mandate, limit your damages to virtually nothing. And you have to ask yourself, if you're going to do thousands, tens of thousands, hundreds of thousands, or millions of dollars of transactions, do you really want to do it on a platform that's not going to stand behind their service? When Web3 hits, you're going to start to see companies that take a different approach to legal liability and do all kinds of interesting things to provide protection for anyone that suffers as Mr. MckImmy did in this case. That's it for today. My name is NFT and blockchain attorney Enrico Schaefer. We'll see you next time.